Hello, my name is Chris Schnee. I'm a writer of science fiction and fantasy, and occasionally real history. I'm here today to explain the recent Supreme Court ruling on the subject of abortion. The point here is very much not to tell you what I think, or how the court should have ruled, only to make sense of what the court actually said. We should talk about this thing in terms of the facts, not the angry arguments I'm already seeing about it. I would just like to make it clear what was said, and try to explain what the reasoning was. My qualifications? I've got a law degree from the University of Virginia, but I can't claim to be a good lawyer, just somebody who has some training in law. And of course, none of this is meant to be legal advice. So let's dive into the ruling and what it says. The case is formally called Dobbs v. Jackson Women's Health Organization. Dobbs is the one bringing the case here, acting as a health officer from Mississippi on behalf of a coalition of 26 American states. The document we're looking at was leaked to the news site Politico on May 2nd, 2022, and it's a draft of a majority opinion. The court has not issued this thing as a real, final, formal ruling, and it might yet change completely, so we can't be sure. They are, by the way, apparently livid that this thing leaked, because leaks just aren't done there, ever. We could speculate about why and who, but this isn't the time for that. The law at the heart of this case is from Mississippi. It says that abortion is illegal there if the fetus is thought to be more than 15 weeks along, or almost 4 months. There is an explicit exception for medical emergencies or a, quote, severe fetal abnormality. So if something horrible happens and the baby is basically already dead, this law does allow abortion. It's not a total ban. In summary, the Supreme Court says here that they are overturning Roe v. Wade, the famous 1973 ruling that says abortion through at least the first 3 months of pregnancy is a constitutional right. They're also overturning a ruling from 1992 called Planned Parenthood v. Casey, which revised the Roe ruling somewhat, but kept the same basic idea of a right to abortion. So Roe and Casey are the rulings here. This is a big deal because it's such a controversial topic. As the ruling itself notes, for decades now we've had potential Supreme Court judges grilled about how they'd rule in a case just like this, and now we're seeing the results of that. So, what was the court's reasoning for overturning these past decisions of Roe and Casey? As the court explains on page 8 of the ruling, there are 3 parts to this argument. First, what makes something a constitutional right anyway? Second, can we find evidence that abortion is a right established by our history and legal tradition? And third, are there other legal reasons that we must protect abortion? The court looks at the Roe v. Wade ruling and what legal basis it had. First of all, there is no explicit reference to abortion in the U.S. Constitution. If you want to find a right to it, it must be implied. It's not stated by name anywhere. The Roe ruling says it's part of a right to privacy. Where is the right to privacy? Somewhere in the First Amendment, or the 4th, the 5th, the 9th, or the 14th, or some combination of those. The ruling offered several different pathways for arguing that it's in there somewhere. The 9th Amendment is about saying that there are other constitutional rights than the ones explicitly listed in the Bill of Rights. So maybe abortion isn't one of those? Or one of the other amendments grants that right, and then the 14th makes it part of all state constitutions? Or it's just a type of liberty that is covered under the 14th Amendment under the heading of due process. The relevant part of the 14th Amendment is Section 1. That's about citizenship, and the exact meaning of that is a controversy in its own right. Let's not get into that. It also says nobody may be denied the privileges and immunities of a citizen, or lose life, liberty, or property except by due process of law, or be denied equal protection of the laws. Basically, this part means that the laws apply equally to everyone, and no branch of government can just rob you or jail you without a trial. It's an important part of what's called the rule of law, which is a very important and much bigger topic than this. Anyway, the courts read this amendment to mean that the Bill of Rights applies at the state level, so not even a state government can ban guns or force you to go to church. If there's an abortion right in the Constitution, then it applies to the states and not just to the federal government. So, does that right appear in the 14th Amendment itself? Is it implied by the idea of due process? The court says that it's answering that by looking at our history and asking if that right is somehow essential to ordered liberty, their term. The court looks back at centuries of American law and back at British law before that, which is standard practice. Courts look as far back as England's Magna Carta from the year 1215, when they want to see how our legal tradition evolved. To give you an idea, 1215 is the time period of Robin Hood and Richard the Lionheart in the Crusades, so they're looking very far back. Anyway, the Supreme Court puts more weight on U.S. law, of course, than it does on Old English law, including what the Founding Fathers wrote, and their commentary on the main text, and the historical context of what they were doing. The Supreme Court spells out that when it's looking for rights and liberties, it must go by the historical record, not by what they might want personally. You might love abortion, but if the legal record doesn't show that it's a long-established right, it isn't. And on page 15, the ruling says, quote, until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain abortion. Zero. None. End quote. In fact, when the 14th Amendment was ratified, 3/4 of the states had made abortion illegal, and eventually all 50 states and D.C. would have some kind of criminal law against it. There were some laws that distinguished between a viable or non-viable fetus in terms of quickening, that is, noticeable movement of the baby, or fetus, whatever you want to say. Even so, the laws typically made it a crime to do abortion at all and just set higher penalties for the later term crime. The court then looked at English law and said the various famous British legal scholars pretty much all mentioned abortion being considered a crime, maybe even manslaughter. Aha, said the pro-abortion people. These English laws tend to specify abortion after this quickening period, therefore they must have meant to protect a right to a first trimester abortion. But the court said no, some of the rulings don't say anything about the quickening thing. None of them say there's actually a right to abort, and it's more like there just weren't reliable pregnancy tests at the time, so how would you even know for certain? So until 1973, abortion was considered some kind of crime in America. Even when the Roe ruling dropped, 30 states had laws against it. So the court here says there's never been any consensus about abortion being a legal or moral right in America, or even England. Far from it, it was usually illegal. So there definitely is not some well-rooted, established right. That means that the 14th Amendment does not bring that right into the Constitution by implication. The court here cites a different case about assisted suicide to say, yeah, maybe society's opinion has changed on this topic, but that doesn't create a new constitutional right. On page 28 of the ruling, the pro-abortion side gets the argument that the 19th century abortion laws were passed for oppressive reasons, like keeping Catholics from breeding. The court answers that you can't cherry-pick some quote from one politician saying, "Waha, let's get rid of the Irish," and attribute that to hundreds of legislators across every state, saying they're all having tainted motives. The court then adds that, gee, if we're looking for evil motives, we can also find quotes from the pro-abortion people that actually do say, we want to get rid of black babies. And in fact, black Americans really do have a high rate of abortion compared to whites. So if we're looking at suspicious motives, we can find that on both sides. The ruling goes on to quote the Casey ruling, quote, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Okay, says the court, you can seek out the mysteries of the universe, but that doesn't give you a constitutional right to do whatever you want. At this point, the court brings up a couple of other controversial rulings. These include Loving v. Virginia, which was the one about interracial marriage, Skinner v. Oklahoma, which was about a right not to be forced into unwanted medical procedures, and Oberfeld v. Hodges, which was the recent gay marriage case. The court outright says that abortion is different from all of these things because, at its heart, it's about the destruction of what is arguably a human life. Whether or not we should call it that, the court doesn't say. But it quotes both the Roe and the Casey rulings, acknowledging that this is a uniquely touchy moral problem. So, the judges say, they are explicitly not doing anything to affect interracial marriage or gay marriage or any of these other things that are being ruled on in other subjects. So the next time somebody says, oh my god, they're going to overturn Loving v. Virginia next, that's just not true. The ruling explicitly says they're not doing anything like that, and you shouldn't read it that way. On page 33, the court addresses the idea that times have changed, and therefore so should abortion rights. Here, and later on, the reply is that maybe the science and culture and other laws have changed so much that we could reconsider the right policy, but it's not the Supreme Court's job to turn that question into a constitutional right. On one hand, you have people saying there are women in the workplace now, so they need the freedom to not have kids. On the other hand, you have people saying that medical tech has improved so much, it's very hard to redefine what is a viable fetus now. Does it depend on whether you live near a really good hospital that can take care of a premature birth? Does it depend on how good your health is, because that affects the chance of the kid surviving after birth? Either we're drawing an arbitrary line at 3 months or some other time, or we're granting human rights to a fetus based on how good mom's medical care is, which the court says would be weird. But the main point here was that this isn't their job to decide that kind of thing. They are courts, not legislators. So then, on page 35, the court looks at the topic called stare decisis, if I'm pronouncing that right. That is the idea that once there's been a legal ruling on something, it should stay put and not get constantly tinkered with. This ruling says that yes, it's generally a good idea to let the ruling stand, for the sake of having a reliable legal system that people can count on. You don't want the law to be overturned every time there's a new election. But it is not an absolute command. In fact, if the court were really bound to never overturn anything, we'd still have rulings like Plessy v. Ferguson, which is the one about separate but equal segregation, an infamous one that got overturned in the ruling of Brown v. Board of Education. We'd also have rulings that allow for banning unions, banning minimum wage laws, and so on. The court is reminding us of all these rulings, and saying sometimes it's better to overturn a stupid ruling than to let it stand. Especially when it's a basic constitutional question, because it's something that Congress can't easily weigh in on. If there's a stupid ruling that interprets, say, a law about boats, Congress should just pass a law saying, no, that's not what we meant, that's not what it should mean, and that takes care of the Supreme Court ruling, makes it irrelevant. But when the court rules on something about the Constitution, all you can really do at that point is try to get overturned by another ruling or pass a new constitutional amendment, which is very hard. So the court is more willing to consider overturning a ruling when it is some key constitutional question. The court decides to look at the factors for whether Roe and Casey are such bad law they're worth overturning. On page 40 it says, yeah, Roe is, quote, egregiously wrong and deeply damaging, and, quote, Roe's constitutional analysis was far outside the bounds of any reasonable interpretation of the various constitutional provisions to which it vaguely pointed. Roe was on a collision course with the Constitution from the day it was decided, and Casey perpetuated its errors. End quote. Page 50 of the ruling cites a famous analysis of the Roe ruling that says not only was it not good constitutional law, it, quote, gives almost no sense of an obligation to try to be. It's written like a set of hospital rules or a law. But again, the ruling tells us, the court's decisions are not supposed to be laws. Making up new rules is not a court's job. It doesn't matter what the judges think the laws should be, they just interpret what the laws actually are, and if you want a different law, you get that from the legislature. See page 61 for where they're hammering that point. The court adds that Roe is not really even a workable ruling because it has required other courts to interpret vague, confusing standards and to bend other laws and legal procedures just to protect this basic pro-abortion rule. The court says it doesn't like doing that kind of thing, where it's bending all the rules to protect this one rule. On page 62, we get to an argument that the court really needs to uphold Roe and Casey, i.e. keep abortion legal nationwide, so that people will respect the court. It'd be a shame if the American people lost faith in the Supreme Court and thought they were being bent by politics instead of looking honestly and rationally at the laws. The ruling here says, yes, that's true, and that's why they went through this whole long analysis. They were looking at the precedent, they were looking at the history and their past rulings and what the logic of the original thing was. They came to the conclusion that the past rulings are wrong and that they're worth overturning. That brings us to an important point that comes up on page 63 and back on page 40. The Casey ruling basically said, there, we have settled abortion forever. Now everybody stop arguing, move on. This ruling says no, the Supreme Court can't take a topic eternally off the table like that. Worse, these court decisions tainted our political and legal system for generations. Why is that? Here's the quote. The court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Casey described itself as calling both sides of the national controversy to resolve their debate. But in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who dissented in any respect from Roe. End quote. In other words, abortion is an emotional and moral dispute that we're still debating. The court in its past rulings said it was picking a winning side and telling the other side to shut up forever. There was no national consensus, no successful effort to get all the states to change their laws, just a court case that set one rule for the entire country. There was suddenly a lot less room for the 50 states to have different opinions and different policies. So the Roe decision taught a lot of Americans that their voices would never be heard again unless they could take control of the Supreme Court and maybe impose their view on everybody. The court became a political football. I'm still basically referencing the Supreme Court's ruling here. They sound frustrated. They're saying that they've noticed that Roe, quote, halted a political process, prolonged divisiveness, and deferred stable settlement of the issue, and inflamed a national issue that has remained bitterly divisive for the past half-century. Their wording. So, ultimately, the court has found that there's no right to abortion anywhere in the Constitution and that the past cases were bad law. Does that mean that abortion is banned now? No. No. The point of this ruling was to say that the Mississippi law is okay under the Constitution. That's it. Not that it's necessarily good law or that the judges like the law. They're just applying a basic test called the rational basis test. They said, okay, since there's nothing in the Constitution barring this, does it have some kind of plausible reason for why it was written? And their answer is yes, it's written to supposedly protect the life of unborn children and protect the life of the mothers and outlaw certain types of abortion that they consider barbaric in their term. So whether or not you like it is at least a plausible reason for why you would have this law. So where things stand, other states are going to be allowed to restrict abortion too, and some of them certainly are going to try. Other states completely disagree, and they're going to want to make abortion totally legal and even subsidize it. We can end up with 50+ different laws and continue to argue about this on the state level. To recap, this new ruling basically says that the states are allowed to restrict or ban abortion if they want to. They're also allowed to not do that. And lost in the fog, I think, is the basic legal argument the Supreme Court made here. They did not say that abortion is bad, just that the Constitution of the United States doesn't force all the states to protect abortion. Whether or not you like this ruling, this is a decision based on logic and evidence, looking back at American and pre-American law and untangling a lot of past argument. If you do like abortion, you can still protect it in your state. If you don't, you can get it banned in your state. So let me draw a bright line here. Everything I've been saying so far has been an attempt to stay on neutral ground and just explain what the ruling says, what the argument is. I'm now going to editorialize a little bit. People are reacting to this ruling emotionally, and this worries me because it's part of a larger trend. Every single topic in American politics is turning into a winner-takes-all fight because it's being done at the national level. Either you win and everybody is forced to accept your rules, or you lose and you feel that you're being oppressed by a hostile force. No matter where you are on the topic of abortion specifically, think about the level of anger this dispute has raised for nearly 50 years. And think about how it's not the only high-profile topic where we're told there has to be one national solution. We're forcing ourselves into a situation where we can't coexist peacefully, agreeing to disagree and living in different states with different rules. I don't like what's going on in your state, and you don't like what my state is doing, and that's okay because we're all Americans. We can agree to disagree. But can we anymore? Are we all Americans still in some meaningful sense? If we really had differences this big and we refused to live in the same country as people who were on the opposing side, then there are a couple of possible outcomes and none of them are pretty. We should start seriously thinking about how to de-escalate in some way, and the solution of winning the next election and then slamming the other side into submission forever is not going to go well for anybody. I could speculate about some other options, but this isn't really the time for that. Soapbox time over. Anyway, I hope you found this video informative, no matter where you are on this issue. We have yet to see whether this is really how the court's final decision goes, since it's possible they'll end up with different reasoning or even a different vote. I found this ruling to be, at the very least, an interesting insight into how judges try to make their decisions, and it was thought-provoking and historically important. Hopefully this explanation made some sense of a complicated legal argument. If you're interested in fiction that I've written, I've linked a couple of my novels below. I write science fiction on the themes of freedom, AI, and transformation, along with fantasy that has engineers, fox people, and water spirits. That's all for now. It's sure to be an exciting next few years. Thanks for listening.